How's everyone doing? Welcome back to another episode of The Banker Next Door. I am your host, Dr. Joe Berquist. In today's episode, I wanted to talk to everybody about a case that was ruled on by the Supreme Court, which became known as the Chevron deference. So I want to read a couple things to everybody today, and then I want to look at an article here at the end that kind of lays out the pros and cons of this, because so what the ruling means in a nutshell, and we'll get into this deeper in a second. I just want to kind of give everybody an overview. So this is a monumental historic ruling on the part of the United States Supreme Court. And basically what this means is and I'll have to take a step back for a second. So when Congress passes a law, it then that law gets sent to the federal agencies, or in this case, for banking industry, say the federal regulators like the OCC and the FDIC and the Federal Reserve and so on and so forth. Now, when they get the law, they kind of interpret it in a very real way as they see fit. And then they basically issue rules and regulation based off that law, based off their interpretation of that law. And it has been literally almost impossible over the last 40 years since the Chevron case originally went down to basically challenge these rules and interpretation by any of these federal regulators or these federal agencies. And so that's why this becomes so monumental, because basically it gives power back to people to challenge things. So in other words, and I'll give you a great example, like the EPA comes down and basically says, hey, you want to put a pool in your backyard. Well, you need all kinds of stormwater management because, this law around environmental whatever was passed. And now, you got to have all this stormwater management done to do this. And basically, as an individual or person, you go back and you say, well, wait a minute, like I read the law. It doesn't seem like that to me. I think your interpretation is being very broad and very vague. And, you guys are just, you created kind of what you wanted to create out of the law, and now you're dropping the hammer on me, so to speak, and there's really nothing that you could do about it. Now this changes the game. This just changes that. This basically says that, like, no, they can't just interpret things as they want. And wait, surprise, surprise, Congress might actually have to do their job. Congress might actually have to write the laws and then provide interpretation on them. That's a shocking. But anyway, let's get into a couple things here. So let me just read a couple things here. So Supreme Court overrules Chevron doctrine, limiting agency discretion to interpret laws. In a major administrative law decision, the Supreme Court overturned the Chevron doctrine, which requires federal courts to defer to agencies' reasonable interpretations of ambiguous statutes. So for 40 years, the so-called Chevron deference, established by the 1984 Chevron versus National Resources Defense Council decision involving the Clean Air Act, has facilitated broad agency discretion in rulemaking. So in the 6-3 decision in Lober-Bright Enterprises versus Raimondo, the majority held that Chevron deference to regulatory agencies defies the Administrative Procedure Act that governs them. In the landmark opinion, the Supreme Court held that, number one, the Administrative Procedure Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency interpretation of law simply because a statute is ambiguous. And this is where it gets back to Congress. Congress might actually have to write laws that make sense, and they might have to interpret those laws. Agencies have no special competence in resolving statutory ambiguities, which should be left to the courts. So what is the regulatory impact here? So the court ruled that the decision does not call into question prior cases that relied on the Chevron framework, but the ruling likely will lead to legal challenges to regulations that depend on administrative interpretations of federal laws, with courts now wielding more authority to invalidate regulatory actions that are inconsistent with statutory authority and the Administrative Procedure Act. So what did our good friend Naomi Snyder, at editor-in-chief for Bank Director, what did she have to say to this? So basically, she wrote a blog piece that basically said, will Chevron be a boon for banks? So the banking industry applauded a major upset last week. The Supreme Court ruled in a 6-3 opinion to overturn the 40-year-old legal precedent known as the Chevron deference, where judges defer to regulatory agencies in interpreting laws when the intent of the law is unclear. Rob Nicholas, who is the CEO of the American Bankers Association, acknowledged the ABA still is reviewing the full implications of the decision in Loper Bright Enterprises versus Raimondo, but he believed it was an important win for accountability and predictability at a time when agencies are unleashing a tsunami of regulation. The New York Times read a headline in response to that decision that said banks stand to benefit from the SCOTUS decision on Chevron doctrine. But will they? Others were not so sure. The doctrine is named after a 1984 case known as Chevron USA versus National Resource Defense Council. We got all that. But the rulemaking from agencies with conservative appointees can be challenged just as easily as rulemaking from agencies with liberal heads. It goes both ways. What may end up happening is even more banking rules end up getting decided by the courts, as some have predicted. The result does not mean less regulation. It just ensures more uncertainty about the obligations the law imposes on regulated entities, wrote Columbia Law School professor Kate Judge. In fact, this sort of uncertainty is prevalent in banking regulation now. Just look at the banking groups and the U.S. Chamber of Commerce's many lawsuits challenging regulation. Among them, judges have temporarily halted implementation of joint rulemaking interpreting the Community Reinvestment Act, as well as the Consumer Financial Protection Bureau's $8 cap on credit card late payments. A court can always avoid getting to the Chevron deference in the first place by saying that a statute is not ambiguous, said Randy Benjenk, a partner at Covington and Burling, in the New York Times article. But in practice, it's been rare for a judge to conclude that a statute is ambiguous and defer to an agency's interpretation of the law. So that is a very interesting take here. Now, obviously, like they said, both sides of the aisle now would have the ability to basically challenge any rulemaking that gets made while the other party is in power. Which again, that's fine. That is actually the way that it should be. That's how you hold the different parties accountable for the idea here is accountability. And the problem is, the reason why this whole thing got passed is because these regulatory agencies have been out of control in a lot of respects for a lot of years, and they have basically created they have interpreted a lot of laws as they have seen fit, and they have created a lot of the ambiguity that exists around this stuff. And then when they get asked about the ambiguity, they then interpret it as they want it to be interpreted. It's all a very big game, and they played it very well over the years. And now I want to bring in this last piece here on this. So this is an article that I saw. It says, U.S. banks see drawbacks from seemingly helpful U.S. Supreme Court ruling. So several recent Supreme Court decisions give banks more power to push back against regulators, but could end up biting the industry. So basically, the Supreme Court had two decisions. You had the Chevron case, and then I'm going to go down here, and then it talks about, decisions. And then there was another case called another recent Supreme Court decision issued July 1st dictates the Administrative Procedure Act 6-year statute of limitations start when a business was injured. So the case Corner Post Inc. versus Board of Governors of the Federal Reserve System was related to the Federal Reserve's debit card interchange fee rule from 2011, thought to be long established. That in turn means that an agency rule can be challenged by any plaintiff who has relatively recently entered a business or business line impacted by a regulation. This is huge. There will always be a new entrant to a business subject to federal regulation that can be recruited to serve as a plaintiff in a lawsuit challenge even decades-old rules. The ruling would allow new banks to challenge old rules, in a nutshell. There is no hard and fast statute of limitations. So all you need to do is come up with a new injured party, and you can challenge any previous rule. So now let's talk about the drawbacks for a second. So while the decisions give banks more power, they could shift how regulators operate and weigh negatively on the industry. To avoid litigation, regulators may take longer to finalize rules, leaving industry participants in limbo. Rulemakings are going to take longer than ever before, and the finished product will carry more uncertainties than it ever did before, because there is no such thing as a final rule in our new legal paradigm. Taking more time to craft rules would be a shift from the current environment in which the agencies have been pretty fast and loose in issuing interpretations without establishing a firm foundation for why an agency position or an agency interpretation is valid. It's going to mean a more careful analysis and producing information supporting their views. Yes, and that's where I think they're like, yeah, okay, it may take longer, but hopefully, the point is to stop abuse. That's the point of this whole thing. So in other words, if you write a rule and right away it's like, yeah, that's going to get challenged immediately, you're going to take a step back and you're going to say, okay, how are we writing this? How is this going to be interpreted? How are we going to enforce this? What are all the conditions and everything, so on and so forth. That is hopefully going to put a pause on this for hopefully a lot of these regulators to basically sit there and say, well, wait a minute, we better make sure we're crossing our T's and dotting our I's and making sure that this is not going to get challenged 5 seconds after we put it out, that we make sure that this is smart regulation that makes sense, that is actually, it's doing something productive, or it's helping or stopping something bad from going on, or protecting consumers, or whatever the case may be. But yeah, hopefully you're putting forth more productive regulation that's not just regulation upon regulation just for the sake of having regulation. If there is an uptick in legal challenges to federal regulators' rulemaking, that could hurt banks more than help them. We'll see a lot of uncertainty in banking, and that is not a good thing, because banks thrive on regulatory predictability. This is true. Replacing regulatory predictability with regulatory paralysis will not lead to good times in banking, quite the contrary. Moreover, agencies could avoid rulemaking to avoid court and instead focus more on regulation by enforcement. We fear that the decisions inject a considerable amount of uncertainty into the regulatory ecosystem and could lead to more regulation by enforcement. But again, yes, but that could be a strategy in the short run. I don't think that's going to work long term, though, because again, you're going to go back to their regulatory enforcement, but enforcement based on what? Enforcement based on regulation that is going to be challenged, and therefore you're going to get more pushback on that. So if regulators decide to take this road of, well, we're just going to drop the hammer and give more enforcement on banks, that's fine. We'll see you in court. That's how that's going to go. Let's see here. Let's see here. And at the same time, regulators could have less power to punish banks using their own internal proceedings under another Supreme Court decision in which the SEC's administrative law judges lost power. While the court's decision is specifically focused on the SEC, its impact could extend to other federal agencies with similar in-house court systems. For example, the CFPB has the ability to use its own internal proceedings or federal court for civil penalties. The Supreme Court decision strips away internal proceedings, leaving just federal court as an option, which is more costly and less ideal than internally handling proceedings, experts said. Well, that depends on which experts you ask. So the agencies will also have to consider what's the risk, what's the benefit of bringing a case. Moreover, the 3 federal bank regulators often use administrative law judges for penalties, and bringing these to court is going to be huge for them. So what's the thing here? So I think that in the short run, you're probably going to see a little bit of messiness. I'll put it that way. Probably going to see a little bit of messiness of this, because I think that there will be things that will be challenged in the courts. There will be things that will be pushed back because, basically a true interpretation from legal challenges will thus come out and will probably lead to certain regulation either being struck down or rewritten or just changed altogether. I think the Community Reinvestment Act being one of those things right now, I think that's a prime example of right now that's in major limbo, and we don't have any kind of satisfactory decision making as it were on that coming anytime soon. But this is a giant giant monumental change. I mean, basically, this seeks to curtail abuses by federal agencies and federal regulators, basically writing their own interpretation to laws, and then basically enforcing it as they see fit. And then, if you try to sue them and you try to go to court, then the judge would just would fall back on that regulator's or federal agency's interpretation of said law. Now that's not going to happen. Now, basically, they're just back in the judge's hand to basically sit there and say, okay, how should this be interpreted? What makes sense here? And like I said, I think long term, this will be a very good thing. I think that it will take a while to kind of work itself out. But I think some of the fear mongering of like, oh, it's just going to be chaos everywhere in the streets, and the regulators are going to be toothless, and they're not going to be able to do anything, and we're not going to be able to pass any laws because everything will get challenged every 5 minutes, and the courts will be the madness. I think that the Chicken Little is a little. I think that's a little melodramatic. Yeah, I mean, will this be a little messy at first? Yes, but I think ultimately will it lead to good things down the road? I think it will be. I'm just a type of person. I believe in a more limited government. I do, and again, to be fair here, I believe in regulation. Regulation is a very good thing. You need regulation on banks. You need regulations to protect businesses, to protect consumers. Banks can and have abused consumers in decades and over the centuries. Things have happened and that have not been good. So you have to have regulation. You absolutely have to have regulation. Banks need to be regulated. You need to have oversight. I would never debate that. Never debate that in 100 years. What I do debate is what I perceive to be over-regulation, and what I perceive to be abusive regulation. And I perceive, and it's like, you get, there's never a time to go back and remove old stuff. It's like they just want to just add layer on layer on layer on layer on layer on layer. And the problem is that a big part of the reason why we've seen a lot of consolidation in the banking industry over the last 40 years is because of bank regulation. It is incredibly expensive to keep up with all this regulation. I mean, you go back to the 80s and 90s, people working in the back office who were, doing back office compliance stuff. I mean, you might have had one person or two people in that department, and you weren't really paying them that much because there wasn't a tremendous. There was stuff to do, but it wasn't like a huge amount of stuff to do. But now, particularly in the last 25 years, I mean that now you have a whole staff of people out there, and these are just cost centers to banks. This is just costing banks more and more money to operate. And again, if you're JP Morgan Chase, yeah, you can afford to have 2,000 people working in compliance for you and everything, because you're making billions of dollars of profit every quarter. Yeah, what do you care? Okay, here's another 300 people for compliance. Okay, whatever. But for banks under 10 billion in asset size, I mean, if you got a $2 billion bank, and you got to hire 25 people to work in back office just to handle BSA and AML and all that, like that is a huge expense to the bank, and that's limiting money that you could be spending to improve your services for banks, to reduce fees, to just add new products to the line. There's all these different things that banks could be spending money on, better cybersecurity protection, all this kind of stuff. So that's really where I'm coming at. I don't like to see and for anybody who sits there and says that basically, the regulators have never abused anyone, they've never abused laws or their power or whatever, like, please save it. Like that's a fallacy. It's an absolute fallacy. It has happened in the past. It will happen in the future. It's a matter of, do we have checks and balances? Are there checks and balances in the system to make it fair that if something is put forward that is egregious and is harming somebody, whether it be an individual or a company or a bank, whatever, that there is recourse for them to seek? Can they go to the courts and seek regress of whatever it is that they perceive to be harming them? That is the thing at hand. And for the last 40 years, the answer to that question was no. They could not go to the court and fight. Now, this basically balances the scale, and it puts it back and says, yeah, if you got a legitimate, great, you can take it to the court and you can have your case heard. And if it is legitimate and you can prove it, or you could put evidence out there, then yeah, you might find yourself with a favorable ruling. So again, this is a monumental event, a monumental shift, and there will be a lot to come for this in the years to come, but we shall see what happens here. But stay tuned. I'm sure there's going to be a lot more on this in the next, I would say the next 6, 12, 18 months. We'll start to see what happens and see if any fireworks begin to fly. So, but anyway, I hope you enjoyed this episode. If you did, please make sure to like, share, and subscribe. Please remember we are on YouTube, Rumble, and all major podcast platforms. Please leave your comments down below, and I will be back to everybody again real soon. Thanks a lot.